You're watching The Source on CNN Philippines. I'm Pinky Webb. Human rights and civic groups have asked the 7-member Comelec and Bank to reverse last week's decision that junked their bid to block Bongbong Marcos's presidential run. They also asked the poll body not to include Marcos's name in the ballots, even if ballot printing has already started over the weekend and his name is listed among the 10 presidential bets. Let's go straight to the source of the story. We have the petitioner's legal counsel, Attorney Theodore Te. Attorney Te, welcome back to the source. Also, thank you for your time.
Thank you, Pinky. Good to be back.
So, you filed a motion asking the Second Division to reverse its earlier ruling that actually junked your petition to cancel the certificate of candidacy of BBM. What I read in your motion is that this is called a partial reconsideration. What is that? Could you explain that to us, please?
Yes, thank you, Pinky. The motion for reconsideration is being filed under the Comelec rules, Rule 23, Section 7, and we are supposed to file it within 5 days, which we did. And the reason why it's called a motion for partial reconsideration is that we are not asking the Second Division to reconsider everything they've written, because there is a portion of their resolution that we do agree with, because they sided with us in that particular point. And that point is that the disclosures that are contained in the certificate of candidacy are material disclosures. Because remember, the ground that we relied on under Rule 23 is that the respondent committed material misrepresentation. By material, we mean that the facts that are required in the COC are determinative of eligibility to continue. So on the Second Division ruled that the disclosures in the certificate of candidacy are indeed material. So we agree with that. So that's why we are not asking the Second Division to reconsider that point. But we do not agree with the finding by the Second Division that the respondent did not commit a misrepresentation in disclosing at least the 2 items in his COC. That's why it's called a motion for partial reconsideration.
It's partial reconsideration. I'm trying to put this simply because the Comelec Second Division said the points that you raised, the points that your group raised are material for the qualification of a particular candidate. Is that correct?
No. The Second Division agreed with us that yes, the disclosures in the certificate of candidacy are material. So on that point, we don't disagree with the Second Division. That's why we are not asking for a reconsideration of that portion of the resolution. We are asking only for reconsideration on the point of that the respondent did not commit a falsehood, did not state a falsehood in his answers, and also in the finding of the Comelec Second Division that we had put in other grounds as well.
So the 2 points raised by your group, from my understanding, is that the Second Division said they were important, but they went on to say, which is part of your partial reconsideration, that this did not prove, while they are important or while they are material, their ruling is that this did not prove that Marcos actually lied or misrepresented himself when he filed his COC. Do we agree with that? Am I understanding it correctly?
Correct. That is the part that one of the parts that we do not agree with. That's why we are seeking a reconsideration of that portion of the decision, of the resolution.
Hindi ho kayo sang-ayon doon sa ruling ng division na hindi siya nag-misrepresent o hindi siya nagsinungaling doon sa kanyang certificate of candidacy. Okay, the 2 points raised here. I want to go back to this. Item number 11 and item number 22. Doon po sa kanyang COC. I want to go to item number 22 first, doon sa certificate of candidacy of former Senator Bongbong Marcos, when he said he was never found guilty of a crime which pertains to his not filing of the ITR from 1982 to 1985. Pero the ruling never imposed a perpetual disqualification from holding public office. I want to relate this, Attorney Ted, please correct me if I'm wrong, to the ruling of the Court of Appeals that did not mention, even obviously it's in this positive portion, that he is perpetually disqualified from holding public office. Is that correct or not?
That is the position of the respondent. And we do not agree with that. In our petition, in our memorandum, we have argued this point. One, that the conviction of the respondent is a fact. It is a final and irrefutable fact. And so there is no arguing with that he has been convicted. He stands convicted by the RTC and affirmed by the Court of Appeals. The only question here is where the perpetual disqualification comes from. Now, the law for which he was convicted, is a violation of the tax code, the National Internal Revenue Code. And in the particular section that is provided in the NIRC at the time of violation, the immediate and automatic consequence of any conviction under the NIRC is that the public officer or employee shall be perpetually disqualified from holding any public office, to vote, and to participate in any election. Automatic yun. So our point is that the conviction carries with it automatically and without need of imposing it, that particular penalty or consequence. And that's why when the respondent put in his answer to box number 22, no, then we are saying that that is not a true statement.
I understand what you're saying with this because basically you're saying that automatic po doon sa nagkaroon po siya ng violation sa tax code. And with that, consequence is the perpetual disqualification. But let me ask you this. Wouldn't it have been clearer, for example, sir, if the CA had put in their decision, hence, Bongbong Marcos is perpetually disqualified from holding public office?
Well, that's hindsight, Pinky. Of course,
Opo.
there are things that could have been made better. Yes, it could have been clearer. But the point that we are saying here is that alam niya yung kaso, no? Hindi niya pwedeng i-deny yun. In fact, inappeal niya sa Court of Appeals. Meron siya mga abogado na nag-a-advise sa kanya. Yung appeal niya from Court of Appeals to the Supreme Court after the Court of Appeals had affirmed the conviction with a modification of the penalty, presumably alam niya yung consequences nun kasi inapilan niya muna sa Supreme Court pero winidraw niya later on yung appeal niya. Again, presumably upon advice of counsel, right? Presumably because this question, box number 22, was a question that called for for legal advice, no? Presumably, nagtanong siya sa abogado niya. Marami siyang abogado, no? And presumably he was advised, right? So, whether the Court of Appeals or the RTC could have been clearer, maybe yes, could have been clearer, but that does not negate the fact that alam niya, no? Alam niya na ganun yung desisyon, alam niya na ganun yung consequence ng desisyon. Nobody is spared. Ignorance of the law excuses no one from its consequences, and therefore alam niya, no? Dapat alam niya, and therefore he cannot claim, he should not be able to claim, as the Comelec Second Division has said, that in good faith hindi niya alam, no? Alam niya yun.
Opo. So where I'm trying to get to is obviously the argument of the both groups. You're basically saying, alam niya eh. Alam niyang perpetually disqualified siya dahil sa sa violation ng tax code. Kasama nito, kapag convicted ka, is perpetual disqualification. Yet you have the group of Bongbong Marcos saying, ito ang ruling ng CA. Ito ang binasehan ng Comelec Second Division. And in that ruling, even if your group is saying, alam niya yon, hindi kasi nakasulat. So basically, that's what I'm trying to understand from both groups, because the Marcos camp can easily and will always use that CA ruling of conviction with no perpetual disqualification.
Well, that's true, Pinky. And precisely one of the issues now that is being raised, no, is precisely good faith ba? Alam ba niya dapat hindi niya alam? Kasi kung hindi naman nakasulat pero alam niya, then it is untrue. When this is probably the first time that this particular box, box number 22 of a standard COC is being litigated. And so the question, is left for the Comelec to decide. Paano nila titingnan yung katotohanan ng sagot ng isang aplikante, sa national position doon sa box number 22, kung sa tingin ng Comelec ay dapat alam niya na ganun yung consequence regardless of how the decision was written. Right? Kung sasabihin ng Comelec na nasasang-ayon sila sa amin, kung sasabihin nilang ganun, nasasang-ayon sila sa posisyon namin na dapat alam niya yan, regardless of what the CA or the RTC has written in its decision, then the statement is untrue. If the Comelec will agree with the respondent na wala naman nakasulat, wala naman nakasulat, and therefore it is not untrue, then it is a question that will ultimately be decided by the Supreme Court.
Okay.
Ito namang decision na to, hindi naman titigilan sa Commission and Bank, I am sure. Regardless of how it will be decided, ang ultimate talaga na landing point nito is the Supreme Court.
There was a decision, in the decision rather of the Second Division, I believe it also went as far as saying that the CA decision, parang they do not have jurisdiction. The Comelec Second Division has no jurisdiction to amend or even review the CA decision, which could have given them the basis on item number 22 to say na hindi siya nag-misrepresent, hindi siya nagsinungaling. Dahil yun, pag ang babasehan lang namin yung CA ruling, wala nakasulat doon na perpetual disqualification, and we have no jurisdiction, Second Division is saying, to interpret that any other way, I guess, or to review and amend that. What do you say to that?
Well, tama naman yun. As a legal point, the Comelec does not have the jurisdiction to review the CA's decision. And in this particular case, this particular decision, because it has long become final and executory. Malino naman yun. And in fact, because the Comelec is not a judicial body, it is a quasi-judicial body, it does not have the authority to review, reverse, modify. And that is not the question here. The CA decision is not at issue. The rightness, the wrongness of the CA decision is not at issue in this particular cancellation case. The only thing at issue here is totoo ba o hindi totoo yung sinabi niya based on facts that cannot anymore be denied, including the RTC decision and the CA decision. So ultimately, again,
sorry, we lost you there for a bit.
How do we read the answer, the no answer of the respondent here, considering the decision of the CA and the RTC as written? As written. Again, hindi natin pwede nang i-second guess, hindi na natin pwede baguhin yung decision. Both parties cannot. We cannot deny that those are the facts. So yun ang pagbabasihan natin.
Let's go to the second point. So dito kinilatis yung certificate of candidacy ni former Senator Bongbong Marcos. We talked about that item number 22. Let's move to the other one. Item number 11. This is where yung I am eligible for the office I seek to be elected to. To which, again, the Second Division said, hindi nagkaroon ng misrepresentation dito. What is your group saying?
Well, again, we disagree with that because item 11, I am eligible for the office I seek to be elected to, has been ruled by the Comelec to be a material item.
Correct.
And therefore, yung pagpirma ng kandidato doon sa item 11, sinasabi na doon na karapat-dapat siyang tumakbo, eligible siyang tumakbo. Now, what does eligibility mean? And this is where the Comelec will have to interpret. Does eligibility mean the various qualifications as provided by the law and the Constitution? Yan lang ba? Or does it mean also that when I, a candidate, represent that I am eligible for the office, whichever office it is, that I also do not suffer from any disqualification? At doon papasok yung epekto ng perpetual disqualification. Dahil kapag ang isang kandidato na perpetually disqualified na under a decision, nonetheless signs a COC with item 11 there, that says I am eligible for the office that I am running for, no, then that would be a false statement. So again, dun yung papasok yung need for the Comelec to interpret that statement. That statement is a pro forma statement. It applies to all candidates who filed that certificate of candidacy. So kailangan tingnan ng Comelec dun yung circumstances behind that statement. So again, I think the question will be, ito ba ay tinutukoy lang dito yung beres qualifications, or does it mean also that the candidate must know at the time that the prospective candidate signs that certificate that one, I am qualified but not disqualified, no? So yun yung position namin, that statement also means that when the candidate affirms, no, in item 11, that candidate is also affirming that he's not disqualified. And in this case, that's not true. No? Because again, that judgment in our position carries with it the automatic disqualification.
Opo. Basically, item number 22 and item number 11, to my understanding, are very related. You know, they're very connected. Almost iisa lang ho talaga yung kanilang pinatutunguhan. However, just as a last question, you also requested in your motion for reconsideration that the members of the Comelec Second Division mandatorily inhibit from the NBank review? Why
yes,
so?
Logical lang naman yung Pinky kasi aakyat ito sa NBank, isi-certify ng clerk of the commission to the commission NBank without need of comment from the adverse party. At pag-akyat sa NBank, no, i-review ng NBank, no, ng Comelec yung resolution. Ngayon, siguro logical lang yon, reasonable lang yon to due process, which includes a fair review, no? That those who wrote the decision should not be part of a review. How can they be objective, right? They will always vote for the decision. So, ang sinasabi namin, yung tatlo nag-decide na. Yun yung position nila. At sa pananaw namin, hindi kami sumasang-ayon doon sa mga parte ng ilang parte ng decision nila. So pag akyat nito, habang ina-apela namin at nire-review ng Comelec and Bank, no, hindi na siguro dapat umpo yung tatlong nag-decide, no? Kasi nga, yun na yung decision nila, yun na yung pasya nila eh. So yung apat na natitirang commissioners ng Comelec forming the rest of the NBank, sila na dapat ang mag-decide. Kasi
very
nga po,
quick question.
Natin, logical yun. They will uphold their own resolution.
Just very quick question. I have 30 seconds left. The second division composed by Antonio Co, Socorro Inting, and Ray Bulay. Antonio Co set to retire Feb 2. Commissioner Guanzon of the first division set to retire as well of first division, and Chairman Abbas. In other words, ang matitira po sa kanila ay apat na lang po. So
yes.
Opo, apat na lang kasi the Antonio Co of second division is also retiring on Feb 2. So doon sa dalawa na nag-rule against your petition, may iwan pa po sa Comelec and Bank. Pero meron pa po ibang mga. How is it going to affect the review of your petition?
Again, internally, I don't know how they will proceed, no? Kasi matitira doon sa apat na hindi nag-decide, no? Dalawa na lang kasi mawawala si Chair, mawawala si Commissioner Guanzon, dalawang matitira. Now, they definitely will not have a quorum, and so siguro mag-aantay sila kung may ma-appoint na bago na ng presidente. Doon sila magde-decide.
Okay. Attorney Theodore Te, sir, thank you so much for your time.
You're welcome, Pinky. Always a pleasure. Thank you.
Thank you. And thank you for joining us here on The Source. I'm Pinky Webb. You're watching CNN Philippines.